Hi, fam. This is Angela Enoch, and I am a director with the Freedmen Agenda League of Michigan. The Freedmen Agenda League of Michigan is a nonprofit organization created to assist and empower the descendants of American slavery. And what I want to talk to you about today is evictions. As you're all aware, the last year has been pretty devastating financially. For a lot of Americans due to COVID, particularly the African American community. And as a result, people have been out of work. They've been, seeking assistance everywhere they can. And it's caused quite an impact in the housing community. The incidence of evictions has been running very high, actually to the point where most of the states had basically implemented COVID moratoriums, eviction moratoriums due to COVID specifically. What happened last year in the summer, most of those expired. And what happened after that was the Center for Disease Control, the CDC, issued their own eviction moratorium, which meant that during that time, your landlord could not evict you. Also, what happened is they provided funds to the states with rental assistance for landlords as well as tenants. Unfortunately, though, that moratorium is going to expire on June 30th, 2021, meaning June of this year. So what I'm going to do is, in this video, try to kind of explain to you what that means, what that's going to look like, if there's still any defenses left using the eviction moratorium, the CDC moratorium, and then what you're going to have to do after the moratorium expires. And like I said, it's due to expire June 30th of this year. Right now, the moratorium is still in effect. As I said, it doesn't expire until June 30th. So what you can do if you're in the process of being evicted now or just got an eviction notice, you can still go to the Center for Disease Control, the CDC website, and download a form. It's called a declaration form. And what you can do is complete that form. It's going to ask you, basically it's like your income, family size, the size of where you're living, things like that. And you would file that with the CDC. And also you have to give a copy to your landlord. So that way, if they try to take you to court, you can indicate that you fall under this eviction moratorium, and then your landlord is aware of that. In addition, there's still some things that could be available to you as far as rental assistance. The state of Michigan, under MISHDA, which is the Michigan State Housing Development Authority, has provided funds or implemented some funds for rental assistance to tenants. Once again, you would have to go to, it's called SARA, the COVID Eviction Relief Assistance Program, SARA, SERA. And what you could do is go to the MISHDA website. And once again, there's a form you can download. And then once again, it's going to ask you family size, income, things like that. And you may be able to get, some funds to provide rental assistance. I think most of these programs have pretty much been dissipated now. I don't know how much there's left in those funds, but it may be something you might want to try because anything that, can assist you would help you. Now, after June 30th, what's going to happen is, people are anticipating there's going to be a lot of evictions. And so I'm just going to now explain, just basically what the process is. What your landlord has to do first, if you're behind on the rent, is send you what's called a 7-day notice. And in this notice, it's going to say, basically, you behind on the rent, say how long you've been behind. It's going to have like the amount, that you're due, how many months. If there are late fees being assessed, it's going to indicate that, and basically have the total of what you owe. And it's going to say if you don't pay the rent within 7 days, the landlord is going to go to court and have you evicted. Now, the first thing you can do with this is look at your lease. That's one of the first things I would advise you to do. Look at your lease and compare it to what the landlord is saying as far as what you may owe. For instance, if your lease says that the landlord is not supposed to assess you late fees until after the 15th day of the month, and you see from notice there, it looks like they're assessing late fees on the 14th day, there may be a defense to the amount that the landlord says you owe. That would be the first thing you could do. And then look and see, look through your records, your notes, bank statements, and, maybe maybe they say you missed 1 month and for sure you paid that month. So you want to reconcile your bank records and all of your statements and receipts with the months and the amount that the landlord says you owe. Or you could also just pay the landlord the money if you have it. Okay, here it is, and just give them the money. Now, after 7 days, if you have not paid the amount that the landlord says you owe, the landlord has to go back to court and get a summons and complaint. The summons is from the court saying that your landlord says you haven't paid the money and you owe this, and the complaint is basically, what you owe and what the landlord expects of you. Now, it's very important to understand that once you get that notice, summons and complaint from the court, it's in the court's hands now. It's an order from the court. So you have to appear at this point. At that point, and I know some people are tempted to, go to the landlord and say, here's the money. But what could happen is if you don't appear in court, you could default. Because I've seen sometimes what happens, the person will go to the landlord, pay them the money, and then not appear in court. And the landlord goes to court and says, oh, well, I don't know why they didn't come. And you default and you're going to be evicted. Now, if you have proof that you pay the money, you may be able to get the eviction set aside, but it's a lot harder, so you want to, appear in court. Now, once you get to court, you have some additional defenses. One of the things is, in Michigan, if your landlord is like a corporation, if it's a management company, Haystack Management Company, that's a corporation. That corporation has to be represented by an attorney in court. It can't be the property manager. It can't be somebody from the business office. It has to be an attorney. So you can raise that, to the judge. Usually the judge will ask that himself, or him or herself, but, if they don't, then you can raise that. Now, of course, that doesn't mean that the case is going to be dismissed. What that's going to do is, buy you more time, which is, the time is always what you want in cases like this, because it gives you more time to get the money or maybe make arrangements to move. But that's one of the defenses. And then the other one is, like I mentioned before, make sure that, the amount coincides with what your lease says. If you, don't remember where your lease is, or lost your lease, or don't know where it is, you could ask your landlord for a copy of it. And if they refuse to give you a copy of it, you can raise that to the judge. So that's another thing. The biggest defense, however, let me back up a minute. Before you go to court, probably the most important thing you want to do is to try, if at all possible, to get an attorney to represent you once it's in the hands of the court. There are some legal aid agencies in southeastern Michigan that you can avail yourself to. There's the Michigan Legal Services, that's one. There's also the United Community Housing Coalition. And then there's Lakeshore Legal Aid. Lakeshore Legal Aid is the big one. They have offices all over for, at least the 3 counties, Oakland, Macomb, and Wayne, and some additional counties, I believe. But any of those agencies should be able to help you. Like I said, it's the Michigan Legal Services, it's the United Community Housing Coalition, and Lakeshore Legal Aid. If, however, you're not able to get an attorney from those agencies, or get assistance anyplace else, you're going to have to represent yourself in court. And like I said, once you go to court, You can raise those defense of, if it's a corporation, if it's represented by attorney, if the lease doesn't coincide with what they say you owe, or you have paid the money. If you paid the money and don't owe this money, you need to bring proof. You need to bring receipts. You need to bring bank statements, anything that shows that you don't owe the money. In absence of that, if you haven't paid the money, the biggest defense in Michigan is, and probably most states, is repair issues. Under Michigan law, rental property has to be kept habitable, meaning it has to be in habitable condition to rent. It has to be safe. It has to be kept up to code. There can't be any the heat has to be working. Heat has to be working. Electricity, can't be any leaks, can't be toilets running, holes in the walls, bugs, pests, things like that. It has to be free of that. So if you have any of those issues, you want to raise them in court. Now, technically, the way it really is supposed to work is, if you have repair issues, you are supposed to let the landlord know. You want to have done that before you get to court. Send them, either email, letter, text, whatever, something that's documented. Because what you want to do is what they call make a paper trail. So you want to have advised the landlord of these issues. And technically the way it's supposed to work is, if you're withholding the rent due to repair issues, you're supposed to be paying the money into escrow. That is like basically paying it into the court every month. If you're in Detroit, it would be 36th District Court, or for example, if you're in Southfield, it would be 46th District Court, and so on. Now, most people don't do that. So if you have not done that, you still want to raise those issues in court. You definitely want to raise those issues in court, but you have to have proof of that. So like I said, you got to take pictures before you go to court. Take pictures, videos, and also bring your proof that you advise the landlord of this. Now, if the judge finds that there are these significant repair issues, what the judge will do is order the landlord to make the repairs. And that could be take another 30 days, 60 days, however long it would take to make these repairs. If you set up an escrow account, you still want to be paying that money to escrow. If not, though, you just have to work that out. So the landlord will be ordered to make the repairs. Now, and once the landlord decides or has decided that he has made the repairs, or it's time to go back to court, the landlord has to bring proof that he or she has made the repairs. So they need to have like pictures, work orders, whatever proof that they need to show the judge that they have made the repairs. Now, if the judge decides that they have made the repairs, what the judge will order you to do is pay the money, the rent that is owed. So that'll be the amount that the landlord originally said, plus whatever the additional month or 2 months or whatever. So at that point, you will have to pay the money. If the judge finds that the landlord has not made the repairs, he or she could order the landlord to make the repairs, or give the landlord more time to make the repairs, or he could also dismiss the case. Either way, it's the onus would be on the landlord to make the repairs, or have the case dismissed. Now, if at that point, once the judge orders you to pay the money, finds that the landlord did make the repairs, and the judge orders you to pay the money, that's what you would have to do. And the judge is only legally able to give you 10 days to either pay the rent money, or vacate the property. Now, there are some instances what you can do is negotiate more time. In fact, that's really the only thing you'd be able to do at that point, is try to get more time from the landlord. The judge is only allowed to give you 10 days. Maybe you could ask for an additional 10 or 15, or maybe the additional 30 days. The landlord probably won't do that if you've raised repair issues or they've made repairs. They probably won't. But it's worth asking. One of the things that I've always cautioned, I was actually a legal aid attorney, and I had these cases all the time, and I've always tried to caution my clients not to let basically the relationship with your landlord become too toxic, too volatile, too hostile. Because when I would negotiate more time for my clients, I was always able to do that. The only time that I wasn't was when the landlord would cite things like, well, no, they've made threats to myself, they've made threats to my family, they've made threats to my property. So it's very important that you try to maintain at least some kind of a cordial relationship with your landlord, because they may be, that may be the only thing that saves you from being basically evicted sooner than you really are able to be. In addition, you want to make sure that you are out by whatever time, that you've been given. If it's the 10 days, if it's 15 days, whatever, you want to be out by then. Now, to be perfectly honest, if you're in Detroit, in Wayne County in Detroit, there's going to be a bit of a backlog. So it won't be 10 days. You probably have maybe even up to 30 days at least, but you don't want to rely on that. You really want to, make plans to leave as soon as possible, because once the time is up, whether or not it's 10 days or 15 or whatever, if you're not out, the landlord is going to go back to court and get a writ. The judge has to sign a writ. And at that point, the bailiffs from the sheriff's office will come and basically just throw your stuff out. Understand it can't be the police, at least are not involved in evictions. It has to be bailiffs from the sheriff's office. But what they do at that point is they come and they throw your stuff out, and it's basically fair game. People in the neighborhood come, they take your stuff, they pick over it. So you don't want that to happen, because once you get that order of eviction, it's going to be on your credit report. So now your credit is messed up, and then you're going to be out of your stuff as well. So you really don't want that to happen. Sometimes it helps if you want to negotiate with the landlord to give you more time. Maybe if you acknowledge the fact that that they want you out and they're losing money with while you're still in the property, because they are. And I think it helps if you try to sometimes acknowledge other people's side, but you have an uncle that says that you can move into his place in another 15 days. He's going to fix up the attic for you, but you just need that additional time. Or you got an aunt that says you can use her van to move your stuff, but it's not going to be available until the 25th. You only have until the 5th, but if you just give me to the 25th, I'll be out by then. But the most important thing is you want to have a plan, for what you're going to do, what you're going to do with your stuff, where you're going to go. Because the idea is to put yourself in the best possible position. And I just want to say, if there are any landlords listening to this, it probably would behoove you to probably be as accommodating as possible. This has been a rough year for everybody, and I think a little kindness is certainly warranted in these cases. And ultimately, you want your property returned to you in reasonable good condition. You don't want it damaged. So I think it's best for everybody to try to be a little accommodating and, show a little kindness to each other. I think that's it. If there's anything additional that I think of, or some new information comes up, I'll probably do another video. But until then, good luck. Just try to, have a plan. Put yourself in the best possible position. And with that, I am done.